5, 4, 3, 2, 1. The golden rule of construction, it has been said, is to ascertain the intention of the parties to the instrument after considering all the words in their ordinary natural sense. To ascertain this intention, the court had to consider the relevant portion of the document as a whole and also to take into account the circumstances under which the particular words were used. Very often, the status and the training of the parties using the words have to be taken into consideration. It has to be borne in mind that very many words are used in more than one sense and that sense differs in different circumstances. Again, even where a particular word has to a trained conveyancer a clear and definite significance, and one can be sure about the sense in which such conveyancer would use it, it may not be reasonable and proper to give the same strict interpretation of the word when used by one who is not so equally skilled in the art of conveyancing. Sometimes it happens in the case of documents as regards disposition of properties, whether they are testamentary or non-testamentary instruments, that there is a clear conflict between what is said in one part of the document and in another. A familiar instance of this is where in an earlier part of the document some property is given absolutely to one person, but later on other directions about the same property are given which conflict with and take away from the absolute title given in the earlier portion. What is to be done where this happens? It is well settled that in case of such a conflict, the earlier disposition of absolute title should prevail and the latter directions of disposition should be disregarded as unsuccessful attempts to restrict the title already given. It is clear, however, that an attempt should always be made to read the two parts of the document harmoniously if possible. It is only when this is not possible, example, where an absolute title is given is in clear and unambiguous terms and the latter provisions trench on the same, that the latter provisions have to be held to be void. This judgment was referred to with approval and followed in Mauleshwar Mani versus Prasad 2002 as follows: SCC P 473 paras 9 to 11. The next question that arises for consideration is the validity of the second part of the will, whereby and whereunder the testator gave the very same property to 9 sons of his daughters. In Ram Kishore Lal versus Kamal Narayan AIR 1963 SC 890, it was held that in a disposition of properties, if there is a clear conflict between what is said in one part of the document and in another, where in an earlier part of the document some property is given absolutely to one person, but later on other directions about the same property are given which conflict with and take away from the absolute title given in the earlier portion. In such a conflict, the earlier disposition of absolute title should prevail and the latter directions of disposition should be disregarded.